to 20.
No, ma'am.
All right. So what we'll do, no problem. So what we'll do, this is the order I'm going to read them in for the record, and we have copies for the attorneys and for the court reporter for right now. Then we'll get copies for the jurors as well. All right, so the jury instructions we read, instruction A, C,
Court's just going through like how they're
D,
going to do this. They're going to do jury
E,
instructions, which I'm kind
U,
of curious about. I don't
V,
normally
as
listen
in
to them.
Victor,
But
L,
jury instructions are interesting
I,
because
M,
I want to know what all the
F,
charges are, and I'm surprised there's not an SA charge in there.
G,
Anybody else think?
X, N, O,
All right, let me turn this up so you can hear. I wish
T,
I could.
2, 4, 10, 12, 16, 36, and 20. Okay? All right. Is there anything else before we bring the jury out?
No, ma'am.
Okay. Okay.
Okay.
Do you guys hear okay? Let's switch to this. It's looking real nervous. I wish I could show you, but TikTok has been so difficult with me lately. And if you're on YouTube, I'm on YouTube too. So he's reading the jury instructions. My shadow's in the room here. There she is. Probably bark at some point. He's looking nervous, you guys. He should be. My big dog's barking.
Good morning, ladies and gentlemen. So for juror number 2, I'm going to have to put you on the payroll. You keep that door open every time you come back. I really appreciate it. All right, ladies and gentlemen of the jury, you now have heard all the evidence in this case. All right, before the lawyers make their closing arguments, the court will give you the instructions of the law that you are to apply in deciding this case. Since it's been quite a while since I gave you the preliminary instructions, I want to remind you that in their closing arguments, the lawyers will refer to the testimony and other evidence that you will have heard, but what the lawyers say in their closing arguments is not itself evidence. Their statements are only their recollection of what the evidence in the case was. It is your collective recollection as 12 jurors of what the evidence in this case was, which shall govern your deliberations. In addition, remember your notes should be used only as an aid to your memory. You should not give your notes precedence over your independent recollection of the evidence, and you should rely on your independent recollection of what the evidence in the case was, and you should not be unduly influenced by the notes of other jurors. In addition, a reminder that the court has sealed the names of the jurors for a year. I want to make sure I remind you of that.
I think we're going to get
As far as the jury instructions are involved, you'll be able to take these written jury instructions into the jury room with you, and we'll make copies for all 12 jurors, okay? So you don't need to take notes on them right now, but I would ask for your attention when I read them, okay? With respect to the instructions I'm about to give, you might notice that at the top of them, some of them are numbered and some of them are lettered. You not have to concern yourself with that. You're just looking at the body of the instruction themselves, okay? Some of the instructions may appear to be in conflict. This is because the court cannot predict your findings of fact. Therefore, the court must instruct you, the jury, on the applicable law under both the Commonwealth's case and the defendant's theory of the case, okay? Brendan Banfield is presumed to be innocent. You should not assume that he is guilty because he has been charged and is on trial. This presumption of innocence remains with him throughout the trial and is enough to require you to find him not guilty unless and until the Commonwealth proves each and every element of the crime beyond a reasonable doubt. This does not require proof beyond all possible doubt, nor is the Commonwealth required to disprove every conceivable circumstance of innocence. However, suspicion or probability of guilt is not enough for a conviction. There is no burden on Brendan Banfield to produce any evidence. A reasonable doubt is a doubt based on your sound judgment after a full and impartial consideration of all the evidence in the case. Any fact that may be proved by direct evidence may also be proved by circumstantial evidence. That is, you may draw all reasonable conclusions from the evidence. You may convict Brendan Banfield on circumstantial evidence alone, or on circumstantial evidence combined with other evidence if you believe from all the evidence that he is guilty beyond a reasonable doubt. When the Commonwealth relies upon circumstantial evidence, the circumstances proved must be consistent with guilt and inconsistent with innocence. It is not sufficient that the circumstances proved create a suspicion of guilt, however strong or even a probability of guilt. The evidence as a whole must exclude every reasonable theory of innocence. You are the judges of the facts, the credibility of the witnesses, and the weight of the evidence.
Oh my
You may consider the appearance and manner of the
He
witnesses on the
just
stand,
couldn't even
their intelligence, their
Dude,
opportunity
he's
for
looking
knowing the truth and
nervous.
for having observed the
looking
things about
really
which they
nervous, you
testify,
guys.
their interest in the outcome of the case,
I'm
their
live
bias,
on
and if
YouTube.
any has been shown, their
you
prior
wanna see
inconsistent
the
statements,
thing too.
or whether they have knowingly testified
But
untruthfully
he's
as to any
nervous.
material fact in the case. You may not arbitrarily disregard believable testimony of a witness.
What's with this
However,
hair?
after
Like,
you've considered
like-
all the evidence in the case, then you may accept or
It's
discard all or
fucking
part of the
crazy.
testimony of a witness as you think proper. You are entitled to use your common sense in judging any testimony. From these things and all the other circumstances of the case, you may decide which witnesses are
I
more
think it is. I
believable
haven't checked
and
it
weigh
in
their
a long
testimony
time.
accordingly.
TikTok absolutely hates me.
If you
and
believe from the evidence that a witness other than Brendan Banfield
out.
previously made a statement
figured I'd
inconsistent
start
with his
up YouTube
testimony at this
too.
trial, the only purpose for which that statement may be considered by you is for its bearing on the witness's credibility. It is not evidence that what the witness previously said is true. The defendant is charged with a crime of aggravated murder. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. Number one, that the defendant killed Christine Banfield and Joseph Ryan. And number two, that the killings were willful, deliberate, and premeditated. And number three, that the killings occurred within a 3-year period. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime is charged, then you shall find the defendant guilty of the aggravated murder of Christine Banfield and Joseph Ryan. If you find that the Commonwealth has failed to...
Well, that's interesting. I didn't know aggravated murder was 3 years, two people. I didn't know the logistics of that. It is the same as a stay-at-home juror is my YouTube channel.
prove beyond a reasonable doubt any of the elements of the crime,
Very
then you shall find the defendant not guilty. The defendant is charged with the crime of aggravated murder. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. Number one, that the defendant killed Christine Banfield and Joseph Ryan. And number two, that the killings were willful, deliberate, and premeditated. And number three, that the killings occurred as part of the same act or transaction. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime as charged, then you shall find the defendant guilty of the aggravated murder of Christine Banfield and Joseph Ryan. If you find that the Commonwealth has failed to prove beyond a reasonable doubt any of the elements of the crime, then you shall find the defendant not guilty. Willful, deliberate, and premeditated means a specific intent to kill adopted at some time before the killing, but which need not exist for any particular length of time. A willful act is one done with a bad purpose or without justifiable excuse, or without ground for believing it is lawful. A willful act is intentional or knowing or voluntary as distinguished from accidental. The terms bad purpose or without justifiable excuse require knowledge that the particular conduct will likely result in injury or illegality. To prove the charge of murder, the Commonwealth does not have to prove a motive for the killing. The presence or absence of a motive may be considered in arriving at your verdict. Brendan Banfield is charged with the crime of using a firearm while committing or attempting to commit murder. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. Number one, that Brendan Banfield used a firearm. And number two, that the use occurred while Brendan Banfield was committing or attempting to commit murder. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime is charged, then you shall find Brendan Banfield guilty. If you find that the Commonwealth has failed to prove beyond a reasonable doubt either or both of the elements of the crime, then you shall find Brendan Banfield not guilty. A firearm is any instrument that is capable of expelling a projectile by force or gunpowder. A firearm is also an object that is not capable of expelling a projectile by force or gunpowder, but gives the appearance of being able to do so. The existence of a firearm may be proved by circumstantial evidence, direct evidence, or both. Brendan Banfield is charged with the crime of child endangerment. The Commonwealth must prove beyond a reasonable doubt the following elements of that crime. Number one, that Brendan Banfield had custody of Valerie Banfield, who was a child under the age of 18. And number two, that he willfully or negligently caused or permitted the life of such child to be endangered. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt both of the above elements of the crime as charged, then you shall find Brendan Banfield guilty of child endangerment. If you find that the Commonwealth has failed to prove beyond a reasonable doubt either or both of the elements of the crime, then you shall find Brendan Banfield not guilty. The fact that Brendan Banfield has been indicted by a grand jury is not evidence against him, and you should not consider it. If there is concerted action with the resulting crime, one of its incidental probable consequences, then whether such crime was originally contemplated or not, all who participated in any way in bringing it about are equally answerable and bound by the acts of every other person connected with the consummation of such resulting crime. You must not consider any matter that was rejected or stricken by the court It is not evidence and should be discarded. You may infer that every person intends the natural and probable consequences of his acts. The Commonwealth bears the burden of proving beyond a reasonable doubt the identity of the defendant as the person who committed the crimes charged. If the Commonwealth has not met this burden, you must find the defendant not guilty. You may consider the character of the defendant when proven by the evidence, whether good or bad, along with the other factors and circumstances in the case in determining his guilt or innocence. The statements presented to you as having been made by the defendant are submitted for your consideration along with all the other evidence. The weight, value, credibility, and reliability of those statements are questions for your determination. If you believe from the evidence that the defendant previously made a statement inconsistent with his testimony at this trial, that previous statement may be considered by you as proof that what the defendant previously said is true. Juliana Perez Magales has testified that she was an accomplice in the commission of the crime charged in the indictment. While you may find your verdict upon her uncorroborated testimony, you should consider such testimony with great care, and you are cautioned as to the danger of convicting the defendant upon the uncorroborated testimony of an accomplice. Nevertheless, if you are satisfied from the evidence of the guilt of the defendant beyond a reasonable doubt, the defendant may be convicted upon the uncorroborated evidence of an accomplice. If you believe that the defendant was without fault in provoking or bringing on the killing of Joseph Ryan, and if you further believe that the defendant reasonably feared under the circumstances that they appeared to him, that he or others were in danger of being killed or that he or others were in danger of great bodily harm, then the killing was in self-defense and you should find the defendant not guilty. The defendant contends that he acted in defense of another person. Under Virginia law, this defense is governed by the same principles that apply to self-defense. Number one, burden of proof. If the evidence raises a reasonable doubt as to whether the defendant acted in lawful defense of another, the jury must find him not guilty. Number two, reasonable belief of imminent danger. The defendant must have had a reasonable belief that the person he sought to protect was in imminent danger of bodily harm. All right, closing arguments.
Thank you, Your Honor. And if we can have the display for the jury activated from our table, and it does include sealed exhibits, so we'd ask it not be displayed to the gallery.
Just to the jury and not
Yes,
to the
please.
gallery.
Thank you.
Wow, we're already on closing arguments. They whipped through those. She looks good. She got like a white blazer top on. For those on TikTok who can't see.
Okay. Good morning.
Display.
Thank you so much, not just for what you're going to do today, but for all of the time that you have spent carefully considering the evidence that we've been able to put before you, for the attention that you've paid, for the notes that you've taken, for the time that you've given up away from your daily lives, your jobs, and your families. Without your work here, Christine Banfield and Joseph Ryan would not be able to find justice. So thank you. The judge has read the instructions to you. They'll go back to the jury room with you, and you're going to have those as your guide in making your decision. I would draw your attention to the fact that you've been given 2 counts of aggravated murder, 1 count of use of a firearm in commission of murder, and 1 count of child endangerment. Talking first about the aggravated murder instructions. They have 3 parts. You'll first need to find that Brendan Banfield killed Christine Banfield and Joseph Ryan. You'll need to find that those killings were willful, deliberate, and premeditated. You'll need to find for one of the counts that those 2 murders occurred within a 3-year period, and for the other count that those 2 murders occurred within the same transaction or occurrence. We know that they were killed during the same event within the Banfield residence, so that should knock that one out for you. 3 years, pretty simple as well. We know that they occurred on the same day. It's the first element that we're going to talk about, that Brendan Banfield killed both Christine Banfield and Joseph Ryan. We know that on February 24th, 2023, he executed his plan to murder his wife and an innocent stranger. He was in love with Juliana. He can pretend that this was a fling, an affair. He'd had them before, no big deal. He was in love with Juliana. He was afraid of losing her. He needed to get rid of his wife so that they could be together, so that they could marry, so that they could have those babies that he was picking out names for. Juliana told us how the plan was crafted and how it played out that morning in the Banfield house. But you've heard directly from our detectives and our experts the uncontradicted evidence of Brendan Banfield's culpability. You needn't rely only on Juliana's story. There has been a plethora of evidence to help you meet your burden in this case. Let's walk through just the highlights. Our digital evidence. While the digital evidence cannot tell us definitively who was behind the screen, we heard that a bunch. We know that to be true. What it can tell us is that Brendan Banfield and Juliana Perez Magalhães are more likely to be the ones to have set up Joe Ryan to come into the house to fake rape Christine on February 24th.
Surprised TikTok's not flipping out on me.
There is no digital history, none, of Christine Banfield using dating sites,
Me too.
fetish sites,
Guilty.
searching for pornography, talking to other men prior to the January inception of this scheme. Brendan told you that more than 10 years ago, there were incidents of affairs involving rough sex. But you have zero evidence to corroborate that self-serving statement. Think about the 2 days of Mr. Litsky's testimony for the defense and the 3 times that Detective Miller was called to this stand. If there was one scintilla of evidence that supported these claims of infidelity, of interest in sexual violence, don't you think you might have heard about it? The FetLife and Telegram contacts all occur on Christine's laptop, frequently while her phone is in use with something completely innocuous. You remember the frozen tickets, the Lululemon shopping, the family vacations the day before the murder? 2 devices, 2 different people. The FetLife and Telegram usage only ever occurred when Brendan Banfield and Juliana Perez Magalhães are in the home. Is it at all plausible that this woman wouldn't take advantage of an empty house to engage in her plans for adultery? That on the 2 weekends that her husband and the nanny are out of the house, those are the 2 weekends where we see 0 FetLife activity, 0 Telegram activity?
Yeah.
Let's look at the chats themselves. Slide 1. How many potential targets were turned down by Juliana and Brendan because they wanted to meet in person first? Because they wanted to talk on the phone? Because they wanted pictures that included Christine's face? Does this make any sense for someone seeking a new relationship in an area of sexual exploration that would be new to them? Why would the real Christine Banfield have been concerned about taking these safety precautions? For that matter, why would the real Christine Banfield have been searching for someone who was willing to engage in knife play when she had a blood clotting disorder? Why would Christine use a phone from a gym bathroom, a photo from a phone taken in a gym bathroom when she has all of these far better pictures available? That one keeps stumping us. There are so many more whys, and I'm sure you have plenty of them in your own heads, but the answer is the same to all of these whys, because it wasn't Christine. It was Brendan Banfield with the help of Juliana.
Good points. Really good.
Let's talk about our physical evidence. You heard from Detective Leach, Dr. Kessler, Ms. McCarthy, Dr. Greenspoon, Ms. Colombo. She was up there forever with all those lab sheets. They gave us a million things to think about. Slide 4. Christine Banfield died as a result of 7 stab wounds to her neck. She suffered massive blood loss. Next, the knife Brendan used to kill her was a kitchen knife with an approximately 4-inch blade, the kind you use for chopping up vegetables. This was the knife that Joe Ryan brought because Anastasia asked him to. This was not the killing knife that Brendan Banfield had envisioned for his scheme. Next, Joe Ryan was shot twice. Once in the head by Brendan Banfield, incapacitating him. A second time by Juliana in the chest, tearing a large hole through his heart
So sad.
and lodging in his spine. His wounds were rapidly fatal, according to Dr. Kessler, and we saw that there was little to no blood from the chest wound. Iris Daly-Graf told you that he would have been incapable of movement following that second shot. Next. We saw evidentiary confirmation of the affair. The semen stains on Juliana's bed sheets. We also saw the photos of Juliana's clothing moved into the primary bedroom when the search warrant was executed in October following the murders. We saw the photos of Brendan and Juliana together, both before and after the murders. Her photos from her Instagram, their family photos in the bedroom after the murder. We saw the records from the shooting range for the purchase of the gun and the training of Juliana to shoot it. Slide 8. We saw the deactivation of the automatic locking feature on the front door at 5:47 a.m. the morning of the murders, done from Christine's phone by the person who knew how the locking system operated, Brendan Banfield. We saw Christine's phone turned off at 6:46 a.m. and hidden in a drawer in a bar table in the kitchen. This is just not where you keep your phone. This is not where we heard that this woman kept her phone. This is not where a person who's about to engage in potentially risky behavior puts her source of help. A floor away, turned off, in a drawer, off to the side of the kitchen. Just doesn't make sense. We saw Brendan Banfield drive to McDonald's and hang out, waiting for the call from Juliana.
That was nuts.
We see their call records, 10 and 11, between Juliana, Christine's phone, which is turned off, Brendan, Christine's phone, which is turned off. They're creating a record. It's a plan. It is premeditated. We see this false attempt to check in on Christine so that they can tell the story to the police when they arrive, that they did everything they possibly could. Next, we see the lock at the top of the basement door that Brendan Banfield did not think to engage to protect his daughter. Even under his own version of this event, he agrees he didn't think about it. He left his 4-year-old child in the basement with guns out, stranger in the house, and something happening that caused him to be concerned.
Good
We
point.
heard the 911 calls. We have a hang up at 7:47 with Joe moaning in the background, and then a 15-minute gap before anyone calls 911 back. 8:02, 15 minutes between when someone in that house thought the police should be there and when they finally asked for help. We saw the body-worn camera and the photos from the scene. Blankets piled near the bodies. Brendan Banfield kneeling on this blue towel. The towel that has very little staining, completely inconsistent with having been used to stop the flow of blood coming from Christine's neck. We heard that the carpet was soaked through to the subfloor.
Sad.
We saw Brendan Banfield's handcuffs that he didn't use. Magazines full of bullets he didn't shoot, collected from him after the murders. And finally, the blood evidence. You heard from Lieutenant Giacchio and former Deputy Chief Ruch that it was Iris Daly-Graf's report that finally pushed this case over the edge and brought the charges against Mr. Banfield months before Juliana decided to flip. That's how strong this evidence is. That's how reliable this evidence is. Ms. Daly-Graf walked us through so many inconsistencies in this scene, proving that it had been manipulated. And you heard absolutely nothing from the defense about this evidence. Mr. Banfield gave you zero explanation for any of this evidence. Slide 15. They have provided no explanation
Space.
for Christine's blood smeared on the right hand of Joe Ryan, leaving voids between the fingers. They have no explanation for the blood smeared across the top of the right onto the left, leaving that void on Joe Ryan's hand where they had been overlapping. Next. For that matter, you have no explanation from defense for how his hands came to be in that position, neatly folded on his chest, covering the bullet wound that penetrated his spine, immobilizing him. How could that have happened if you are to believe Mr. Banfield?
He's like,
There's been no explanation for the bloody hand-like smears on Joseph Ryan's jeans containing Christine Banfield's DNA. There's been no explanation from defense for how his jeans ended up bunched under his rear. Next slide. There's been nothing to tell us why a mixture of Joseph Ryan and Christine Banfield's blood, a mixture, could possibly have been on the inside of his waistband at the buttonhole, on the button, and on the zipper. Nothing from the defense to explain how Joe Ryan could possibly have manipulated his pants after being shot in the head, given that no other bleeding wounds were present. If his blood is on those pants, on that button, on that zipper, he was bleeding when they were touched. How could he, Joseph Ryan, have been the one to touch his button, his zipper, the waistband of his pants, to pull them down in that fashion? Brendan told you he never touched Joseph Ryan. And yet we have distinctive finger-shaped parallel lines on Joseph Ryan's arm and small circular stains consistent with blood having been dropped from above while Joseph Ryan lay on his back. Next. And then there's the blood on Joe's hip. Blood that traveled onto his body and then ran down to the floor with the assistance of gravity while he lay prone. It couldn't have come from his chest. That wound barely bled. He was laying down when blood was shed. Makes it pretty impossible that he stabbed Christine Banfield. Next.
she's doing good.
On the other hand, Brendan Banfield has cast off on his jeans. He has blood all over his hands. The blood stains on the backpack don't line up with the position of its contents. The blood on Joe's face is not consistent with his final position. And I'm sorry, I'm back to Joe's hands. This scene was manipulated. And it wasn't by Joe. It wasn't by Christine. And according to him, Juliana didn't do it. You have zero explanation from the defense as to how all of this blood evidence